Rise. Use now session.
All right, I want to say good afternoon to everyone, and let's go ahead and set forth our appearances in the Gallagher versus Affinity Lifestyles et al. Matter. We'll start first with the plaintiff, then we'll move to the defense.
Welcome to plaintiffs, and we expect Mr. Parker will come in about 3. He's finishing a deposition of Dr. Hudson right now.
Okay,
Good afternoon, Your Honor. Joel Odou and Robert Eisenberg on behalf of Blue Water Inc. and AffinityLifestyles.com Inc.
Elizabeth Lowell for Milwaukee Instruments.
Good morning, Abe Smith and Dan Polsenberg, also for Milwaukee.
all right.
Morning or good afternoon, Your Honor. Joe Reynolds. on
Yeah,
behalf-
good afternoon to everyone.
Joe Reynolds on behalf of Instruments.
Oh,
Good afternoon, Your Honor. Ramas Gali, also on behalf of Hanna Instruments.
Good afternoon, Your Honor. Chad Fears, also on behalf of Hanna.
all right, I just want to say once again, good afternoon, and where did we leave off?
Your Honor, I believe we got through Milwaukee's motion for new trial. It seems like the next place to go might be Milwaukee's motion for Rule 50B relief.
All right,
And Ms. Lowell will be taking the bulk of the argument. I may have a few words to say at the end.
okay.
Yeah,
And for the record, I just want to make sure we're clear which number we talking about.
1297.
1297, that would be defendant Milwaukee Instruments renewed motion for judgment as a matter of law pursuant to 50B.
yes,
And motion for new trial pursuant to 59.
yes, Your Honor.
All right, just want to make sure we're clear. And it helps you out, right? Phil? Ma'am, you have the floor, or you can take the lectern, or you can stay there, whatever is comfortable for you.
Thank you very much. I know that's great.
Okay.
So this is our motion for under Rule 50B. We're requesting judgment in favor of Milwaukee and against plaintiffs on both of their claims, on the strict product liability failure to warn claim and on the breach of warranty, implied warranty for fitness for a particular purpose. The reason that we're asking for that is we maintain that plaintiffs do not have standing to bring either of those. And so when I was thinking about this motion, I think the analysis for both the strict products liability and the breach of implied warranty is relatively simple. We've gone over it several times. There have been a number of briefings on it. But I did note that there were some issues that I thought I could address preliminarily to set out Milwaukee's position and discuss areas where I thought the record could be possibly clarified.
Ma'am, you have the floor.
I'm going to start with those. First, this sounds very simple, but there are 2 claims that plaintiffs are asserting. That would be, then we get to the second one, which is those 2 claims have 2 different analyses. The first claim, the claim for strict products liability, that is an analysis under the Nevada Supreme Court's adoption of 402A from the restatement second. And in order to do that kind of standing analysis, you just need to look at the text of 402A, which the Nevada Supreme Court has cited many times with approval. And then we kind of go into a common law analysis where we're looking at what the Nevada Supreme Court said and when it applied 402A in different cases and the various circumstances of the plaintiffs that have brought claims under 402A in Nevada. Finally, we could look at what other state courts have done when applying 402A. So that's kind of a common law analysis. When you get to plaintiffs' claim for breach of implied warranty of fitness for a particular purpose, that's a very different analysis because plaintiffs are making a claim under a statute, NRS 104-2315, And when we're doing a statutory standing analysis, we're gonna look at the plain language of the statute. We're gonna apply it as written and, try not to add language that's not there or subtract language that is there. Then possibly if it's ambiguous, we might, the court might look at something like that and look at the legislative history. But again, those two analyses are very different. And the reason I bring that up is because when I was reading the opposition, it seemed to me that at times it tried to mush those two, that's a technical term, tried to mush those two analyses together. For example, in section C, it says, Nevada does not require horizontal privity for product defect or breach of implied warranty claims. Again, these are two separate analyses. Addressing the second claim, which is for statute, under a statute. I want to say, how do we know it's under NRS 104-2315? Because this claim, it has kind of a tortured history, which I might get into. First of all, we know it's under NRS 104-2315 because plaintiffs cite to NRS 104-2315 in a lot of the filings that they have submitted discussing this. In the 10 cases that were filed at the same time as this one, they contain the same allegations and are coordinated under discovery. Those 10 cases, they have amended complaints with a breach of implied warranty of fitness for a particular purpose claim. And in those complaints, there actually is a citation to NRS 104-2315 in plaintiff's motion for summary judgment number 6 in this case, which was filed in June. Plaintiffs again cited to NRS 104-2315. And in their opposition to our motion today, they again cited NRS 104-2315. So that's Milwaukee's taking them at their word that this is a statutory claim. However, as the court knows, this claim had kind of a different history, and that it was not included in plaintiff's amended complaint, which was filed in March, or at least that's Milwaukee's position. Plaintiffs may dispute that. There were several discussions with the court about the fact that the claim was not in plaintiff's complaint, and that the court, when discussing the motion for summary judgment number 6, had not granted a request to amend the complaint. So on September 27th, while we were discussing this, the court said, well, what does Rule 15b say? And from that, I think everyone understood that the court was adding this second claim, this claim for breach of implied warranty of fitness for a particular purpose, as a rule under Rule 15. That is, it wasn't in the complaint, but it was added at trial based on the evidence. And so because there was this history, and because there's no kind of written description of the claim, we think it's a statutory claim, but maybe the court was thinking of something else when the court added it on September 27th under Rule 15b. And it might be helpful to clarify that issue, because as I said, I'm saying there are two analyses, one under 402A and one under the statute. But if the claim that was added is not a UCC claim, then that I might need to amend my motion or say something different, and I'm prepared to do that. But I just wanted to bring up that kind of the unusual history and the question as to what exactly that second claim for breach of implied warranty was. The other reason I should mention that we think there is some need for clarification is the fact that we had a discussion regarding jury instructions on the second claim. Plaintiffs submitted what became the jury instructions, jury instruction 32 and 33. Milwaukee objected, saying, hey, this language does not track the UCC statute. And in response, Milwaukee offered their own jury instructions. Those were rejected. But the quote that I have from the transcript that came from the court says, and this is on October 2nd, on page 10, lines 1 through 4, says the statutes in question are based on Article 2 of the UCC, but you do have common law in breach of warranty claims that were there prior to the UCC enactment. So I guess what I'm saying is, if the court here today clarifies that, then perhaps we don't have a UCC standing analysis. And then we would have a different section of the argument that I'm not planning on doing, but I'm waiting to hear. Finally, the last issue that I thought was kind of a rabbit hole that I wanted to get out in front of is the issue of the term privity. I'll just say, I don't think that privity is very helpful, using that term in the context of the standing analysis. Other people can use it, but the reason I don't think it's helpful is because privity, the term, it has multiple uses. You can use it in talking about contract claims, contractual privity. You can use it when you're talking about res judicata or collateral estoppel. And even just talking about the analysis of a breach of implied warranty claim, you have two kinds of privity, as the Supreme Court said in Hiles. That's a 1977 case, citation 93, Nevada 73, and footnote 5. There are two kinds of privity, even in that context. There's vertical privity and there's horizontal privity. And we spend a lot of time defining them there. I'm not going to go into that, but in the Hiles case, you can see they really discuss there's this kind of privity and there's that kind of privity, and we're discussing this kind of privity, but then they start striking the modifier. So they use privity without specifying what they mean, which I think creates some opportunities for citing, saying, oh, the Nevada Supreme Court doesn't require privity, when if you look in context at the case, that is not exactly the meaning of the Hiles case. So those are the 4 issues that I kind of wanted to cover at the outset. And then I'll just quickly go through the 2 analyses, and I'll let Mr. Smith kind of expand on those just a little bit. So the analysis under 402A is based on, it doesn't use the term privity. That was what I wanted to say. So you really don't need to talk about that. It says, it talks about liability of a seller of a defective product to the ultimate user or consumer who has injury. Comment, and clearly plaintiffs are not a user or consumer of the ORP meter. So under the actual language of 402A, they are not going to qualify as a person withstanding to bring a claim for strict products liability. Comment L defines users and consumers, and comment L, says it wants to make a very broad user and consumer. However, even under those broad definitions, I don't think you can get to a place where plaintiffs would qualify as users or consumers. And I think plaintiffs pretty much concede that they are not users and consumers. Their argument is that they come under comment O to section 402A, which is concerning another group of people who are not consumers, not users, who are bystanders, who came in contact with the product and were injured. And plaintiffs have cited a number of cases in which they say, hey, these plaintiffs were bystanders and they went up to this Nevada Supreme Court, and the Nevada Supreme Court didn't say, hey, you're not a user, you're not a consumer, you know that. Therefore, bystanders are recognized in Nevada. I'm not sure that that is the case, but that is not our argument. We are not saying that Nevada does not recognize the ability of a bystander to bring a strict products liability claim. For the purposes of this motion, we are saying plaintiffs are not bystanders because you need contact with the product. You need some sort of geographical and temporal proximity, and plaintiffs do not have any of those things. Therefore,
Tell me, what do I do though, like under the facts of this case where the instrument at issue was used as part of the manufacturing process? Ultimately, and remember, we had the motion as it pertained to fitness for a particular purpose, and that was granted. And just as important too, I mean, we go back and look at a lot of these cases, but one thing the Nevada Supreme Court has done, and they've looked at, for example, strict products liability, and they've made a determination that they don't want to follow the more restrictive view under the restatement of torts 402(a)(3), that we're going to follow the consumer expectation test, right, which is a broader test. So my question is this: under those circumstances, what do I do? Because one thing we do know for sure, as far as the manufacturing process is concerned, the meters at issue were used as part of the process. And then we had testimony regarding that specific issue. And if I'm wrong, you can correct me. I mean, that doesn't bother me at all. But it appeared to me that there was testimony that it was known that these meters were being used for that purpose, you know? And so what do I do under those circumstances? Because, I mean, yeah, we talk about privity, I get it, but at the end of the day, we're still talking about a product that was placed in the stream of commerce and that was utilized, and the jury's made a decision as far as that product is concerned, right? They have.
right.
And in fact, from a manufacturing perspective, Real Water admitted that it was effective, right? Admitted liability, right? So what do we do under those circumstances? Because that's a much more unique scenario.
Well, I have a.
Because we can all admit the laws changed and it's evolved a lot over the last 3, 4, 5 decades.
Right. Well, first of all, plaintiffs are not without recourse, right? They have a claim against Real Water. Real Water is the product that injured them. It was not, you know, maybe they made. So they have a claim against the manufacturer of the product that injured them. And our meter is not a component part of that product.
What is it then? If it's not, I mean, and I'm only asking that because I think there was testimony that the meter at issue was utilized as part of the manufacturing process, right? Now, is there a difference between a component part and or being used during the process? And here's my point. Say hypothetically, that you have this scenario where you had some sort of manufacturing software that was used during a process, and the software was used for the purposes of, say, making sure that the components fit within certain manufacturing guidelines and tolerances, right? Okay, so but this software, whatever the program will be, at the end of the day, doesn't become an integral part of the product at the very end. But it was used in the manufacturing process, right? Are you saying under those circumstances, since it wasn't a component, but it was used to manufacture components, that under that limited set of circumstances, if the software was faulty, there would be no strict products liability claim against the software manufacturer?
I think there would be the plaintiffs who were.
Very good question.
By the
I have
detective.
a very short answer.
I understand, I know it is gonna be, but I'm gonna listen to her first.
The plaintiff was injured by the defective product that the software created, right? They
Right.
have a claim against the defective product. And it's the responsibility of that seller, that manufacturer, to make sure their software works, right? Thus, the manufacturer, if they purchase software that doesn't work and it injured their product, then they are the real parties in interest. They have a claim against the software manufacturer because they're the ones who are they are the user and consumer of the software.
No,
But-
I'm not saying that the end user is a consumer of the software. It's a slightly different scenario there. I'm saying that that software package was utilized as part of the manufacturing process, say for component parts. And lo and behold, there was a problem with the software and didn't function appropriately, and maybe the metallurgy was off. Something like that, you know, I mean, I don't know, I'm just kind of throwing that out there. But my reason for it is this, at the end of the day, the software doesn't become a component part. It was a component part that was utilized during the manufacturing process. And so you're saying, look, just because it wasn't a component part, there would be no claim for strict products liability vis-a-vis the software manufacturer.
Correct, and I agree, that's what I'm saying. The plaintiffs would have a claim against the defective product that injured them, not something up the chain that was not a component part of the defective product that injured them. And I think where you're going is really to section 1 of the restatement third. And I think what plaintiffs are asking you to adopt is essentially section 1 of the restatement third, which says one engaged in the business of selling or otherwise distributing products who sells or distributes a defective product is subject to liability for harm to persons or property caused by the defect. If we adopted section 1 of the restatement third in Nevada, then plaintiffs would have a clearer path. But
And here's my next question, what do you do? And I understand that, but what do you do in light of the consumer expectation test that's been adopted by our Nevada Supreme Court?
well, the consumer is the person who's using the product or consuming the product, isn't it?
Well, yeah, I mean, and it's my understanding that our Nevada Supreme Court rejected what was it, risk benefit analysis or something like that, and said, look, we wanted something more expansive as far as protections are concerned for consumers.
And my response.
Something like that, right? You know what they
They
say?
did, and that's because
I know Mr. Polsenberg doesn't like that, but
the restatement.
no, you'll give, I'm gonna listen.
Respect, not the way you worded it.
Okay, I didn't like the way I worded it. But I'm gonna let you word it how it says it exactly in the case, Mr. Polsenberg. But go ahead, ma'am. I don't want to cut you off because you have the floor.
And the restatement third and the restatement second have different ways of balancing the interests of the various parties, because
They do,
there are
they do,
plaintiffs,
yeah.
right? The plaintiffs who are injured and they have an interest in recovery, but they're also manufacturers and they don't want to be hailed into court on claims based on, on people who misuse their products. And then there are also other consumers who are maybe using the product more carefully, who are not injured, and they like the product. They want to keep the product on the market, right? And they don't want to pay more for the product because the manufacturer had to pay a large judgment because of a perfectly good product, right? All of those interests have to be balanced when you're looking at strict products liability. The restatement second has one balance. The restatement third has another balance. I would say section 1 of the restatement third is a more expansive definition of who can bring a claim, but then it has a stricter test for whether a product is defective. So you can't really, I don't think you can have one without the other, because they're different balances. In the restatement second, we have a smaller group of people who can bring a claim. It's limited. It's not anyone who is injured. It is a user, a consumer, possibly a bystander. And yet you have a more expansive test for a defective product, and that is the consumer expectation test. So plaintiffs are asking you to kind of mix and match, keep the consumer expectation test, but expand in an unprecedented manner the group of people who can bring a strict products liability claim. And I'll tell you, the reason I say it's unprecedented is I'm not a workaholic, but I've been looking for the case that proves that they're right. I've been looking for a case in which there is a bystander who didn't use, didn't touch, didn't buy, wasn't in the same room with the product.
But doesn't it come down to how we define the product? Because at the end of the day, the product here would be the water that was disseminated, and then it comes down because we can't we can't create artificial distinctions because the product is the water, right? And it's real water. And so the issue comes down to where do we limit exposure for potential individuals involved in the manufacturing process, right? And if your product is part of the manufacturing process, what do you do under those circumstances? And that's ultimately what it comes to, because the plaintiff has taken a position that the orb meters that were involved in this case were part of the manufacturing process, right? And they filed a motion for partial summary judgment. It's my recollection as it related to the one issue as it pertains to fitness for a particular purpose, right? And
But
so
that's a separate.
no, but I understand that, but still, factually, it goes to this orb meter was being utilized in the alkaline water manufacturing process. It's probably the best way I can say it, you know.
And that is, again, an unprecedented expansion. We have expanded the strict liability to component parts of the defective product. I don't think any court has expanded strict products liability to products that are used in the production of another product.
All right.
And so it's kind of like in the Shoshone bottling case, the plaintiff found a mouse in the bottle. It's as if that plaintiff sued the maker of the mouse traps that were being used in the bottling facility of the Shoshone people.
I had a question for you, though. Is there a difference between mouse traps that are used for the purposes of pest control versus an orb meter that's being utilized to produce alkaline water?
But the orb meter has actually, I would say the maker of the mousetrap has more notice that its product is going to be used for the purposes of keeping mice out of bottles than the orb meter, which has all it does is it measures negative and positive charge. There's nothing in the directions that say, oh, you can add, you can subtract, you know.
But
they
in
have no
that,
notice.
didn't that go to the issue regarding the whether or not, and I think it kind of ties in. I mean, I see it, the fitness for a particular purpose, because that really goes to the fact that the orb manufacturer knew the purpose upon which the orb meter was being used by real water in this case. And I thought the testimony is fairly uncontroverted in that regard, right? And so, you know, mouse traps are mouse traps, right? We can all agree. And orb meters have various different uses, and we can all agree on that. I remember our vast discussion during trial regarding orb meters and the like. But the question is this: what happens if that instrument is being used as part of not making sure that the facility is free of vermin, mouses, you know, bugs, and so on, but it's being used as an integral part of the process, like for measuring. And here's the thing, I mean, I understand the position you're taking, but I would anticipate potentially, if you look around either in aviation disasters and litigation, or you look at some of the pharmaceutical cases involving pharmacies and drug manufacturing and component parts and all those types of things, there might be a little bit of overlap of of items or machinery or something being utilized as part of the process that results in a product that's allegedly defective. I guess it was a defective product at the end of the day, and what their potential exposure can be. And that's what's really unique about this case, because we're not talking about the mousetraps, or we're talking about something utilized during the manufacturing process, which is a little bit different. And the only reason I circle back to the consumer expectation test, which our Nevada Supreme Court adopted because they thought it was broader and it gave the consumer more protection than a risk benefit analysis, and that's what they did. I guess it was Justice Stiglitz, right? Wasn't that who made that determination ultimately? But it's a fascinating issue. But go ahead, ma'am. I'm asking questions. And the reason I'm doing it is so we can have a clearer record here. And because I know there's certain justices on the Supreme Court, they read these transcripts. I've witnessed it because I've been in chambers. They read them.
So one more thing, and then I'm gonna, I'm sure Mr. Smith has a couple of things to
I'm quite
in
sure.
response to your questions. I'll just say, you're saying, I'm sure there is, that I looked for cases that were analogous to this one. I assume plaintiffs did too. I provided an exhibit C to this reply. I took all of the cases cited in the opposition. I put a little blurb next to them. This is what plaintiffs' contact with the defective product was. None of them, all of them have contact or geographical and temporal proximity. All of the cases cited by plaintiffs, they support my position. They don't support plaintiffs' idea that we can be, way downstream, far removed, not.
But see, I don't see this as an upstream, downstream type scenario. And the reason why I say that is when you talk about upstream, downstream, typically you're dealing with, distributors, and they're not really part of the process whatsoever. They just help put the product in the stream of commerce, right? And so they're not really part of the process. Here, it seems to me, and this is the distinction, and I think potentially there could be a greater argument made by that instrumentalities, devices, et cetera, are part of the process. And why should they be exempt from liability when you just have someone that's in the chain of distribution and is not part of the process at all? They just deliver it, or they're the wholesaler, or those types of things. And yet 402A will reach them, right? We can all agree on that.
I would disagree. I think 402A is the restatement second has one balance. The restatement third has another balance. And I'm gonna maybe Mr. Smith wants to respond.
No, ma'am. I don't want you to sit down unless you want to. You've done a wonderful job.
But we can keep talking, Your Honor.
That was a lovely discussion.
And Your Honor, I'm actually, I've been intrigued by this case for a long time. And I know you find this case interesting. And I assume this is why you became a judge in part, because you get to deal with these interesting cases.
I don't know.
Oh, okay. Well, you don't have to admit that on the record.
I don't know. But I will say this, over the last 18 years, I've really enjoyed myself. And it's been a wonderful experience as a trial judge. And I sometimes wonder how much longer I'll do it. And every day I wake up, I think, why not do another 6, right? I don't mind saying that, but I don't have to worry about that until the end of 2026. So I got a little time.
Six decades?
No,
Oh, okay.
no. 2026. No, 6 decades. I don't think any of us will be around then, Mr. Polsenberg,
I think Joe will.
Okay, but no, sir, you have the floor, but
Yeah,
you're right.
well, and I'll admit that I became, well, I don't know if I became a lawyer, but I got into this area of practice because I thought these sort of questions were
I'm
very
very tired of talking to clients. We'll keep the record, you know how that is.
fair enough. Your Honor.
I think everybody can agree with that. It doesn't matter whether you're talking to claims examiners, plaintiffs, or business clients. They all have unreasonable expectations, and they can become very difficult. I don't mind saying it. You'll find this out one day when you stop practice. You go through a detoxification period. You really do. And you realize that there's a real world out there, and it's not the world that lawyers live in day to day. There just is. And one day we'll have coffee and I can go into great detail on that for you. But so you have the floor.
Thank you, Your Honor. I'm glad you brought up the Ford versus Trejo case. Because I think that was Justice Stiglitz's opinion, and there was very significant for the development of products liability law in Nevada. And Ms. Lowell, she did talk about the balance that the second restatement, section 402A, strikes versus the third restatement, sections 1 and 2. So the risk utility test, is found in section 2. Section 1 also talks about what makes a product defective. And both of those sections also talk about the kinds of plaintiffs that are entitled to sue under the third restatement. And Ms. Lowell is correct that the third restatement, it imposes a more stringent test for a plaintiff to prove a product defect, because they do have to show in some cases that there's, that there is a reasonable alternative design. And then the defendant can defend by saying, look, the risks or the benefit of this product, the utility of this product outweighs the risk posed by this product. So in that sense, it makes proving a case more difficult for plaintiffs. The balance, though, is that it does expand the pool of potential plaintiffs by making it tied to a foreseeability analysis in terms of who could foreseeably be injured by the product. As we know, the Supreme Court rejected the restatement third, and it didn't say we're rejecting the risk utility test, but we're open to a more expansive view of plaintiffs of plaintiff standing than is allowed under section 402A. The reason is because the Supreme Court was very clear in the majority opinion about why it was rejecting the risk utility test. And it wasn't just that, oh, we don't like, Justice Scalia said that he's not a fan of modern restatements because they tend to say what the law should be instead of restating what the law is. But that wasn't the reason for rejecting the third restatement approach. It was, in the words of Justice Stiglitz, that it imported negligence concepts into a strict liability test. So the majority goes through the two different tests, consumer expectations and then risk utility. And then she says, look, in addition to our determination that the proposed benefits of the risk utility test are overstated, the risk utility approach also prevents several tangible disadvantages. In talking about in Shoshone, the bottling case, saying you didn't want the manufacturer to be able to defend just by saying, oh, well, we exercised all reasonable care. So even if a mouse ended up in one of the bottles, we should be absolved of liability because we weren't negligent. Accordingly,
Well, and see, well, I mean, that's actually problematic.
Yeah.
Because at the end of the day, when you're talking about strict products liability, the thrust and focus is on the product design itself. Exactly, and whether it's a defective product or reasonably dangerous under 402A. That's exactly what it is. A real good example, and Mr. Polsenberg probably remembers this, but this is going back to the J.C. Penney's case, right? And that was tried from a defense perspective, i.e., what did we do wrong, right? And yeah, well, what she did wrong was she made that argument in front of the jury, and the thrust and focus should be the defective nature of the product, if any. Right, that's what the thrust and focus is on. And so here's my question, and we talk about a foreseeability analysis, and here's my question as far as that's concerned, because typically when you talk about foreseeability, you're talking about triggering duty, and just as important too when it comes to foreseeability, one of the hallmarks of foreseeability is this: you don't have to foresee the exact nature of the harm, it's just that potentially a harm could occur. Right? That's foreseeability, triggering duties. And so this is the natural line of logic, which is saying is this, that if hypothetically, if you have a component part that's being utilized in the manufacturing process, but ultimately doesn't become a component, under those circumstances, there's no duty to the end user, because it's not foreseeable, something like that. That's kind of,
that's not my argument, Your Honor.
okay, well, it kind of ends up there.
No,
But
no.
if that's not your argument, I'm gonna let you rephrase your.
Okay, well, let me finish with Trejo because this will segue into what I think the claim really is and where the duty lies. So in Trejo, Justice Stiglitz says that consumer expectation test focuses, as you say, on the reasonable expectations of a consumer regarding the use and performance of a product. But rather than focus on the product itself, the risk utility test subverts this analysis, focusing on the foreseeable risks of harm apparent to a manufacturer when adopting a design. This imports a negligence standard into an area of law where this court has intentionally departed from traditional negligence analysis.
We all agree.
We all agree. And this is where I think the claim would lie. I agree. There is potentially a duty, and there is potentially a foreseeable harm. And that is a negligence concept. We don't dispute that had plaintiffs brought a negligence case, there would be a different analysis here. The analysis would not be, are you a user, consumer, or bystander? And it wouldn't be an analysis, a strict liability analysis of, unreasonably dangerous under a consumer expectation test. No, they'd have the whole panoply of remedies available to plaintiffs who sue in negligence cases. In fact,
This is the question, and is the foreseeability any different in a strict products liability versus negligence
yes,
as it pertains to duty analysis?
yes, there is no foreseeability analysis in strict products liability. Foreseeability is a concept from negligence. In fact, in section 388 of the second restatement, which Justice Rose cites in his concurring opinion in Allison versus Merck, there's actually a test that adopted for one who supplies directly or through a third person a chattel for another to use, to those to whom the supplier should expect to use the chattel with the consent of the other, or to be endangered by its profitable use. That's a lot of use of the word chattel. But the way I understand that section is that in negligence, and 388 is a negligence section, it's not under the strict liability umbrella. In negligence, there may be a duty for somebody that provides a product that's used in the manufacture of another product and that could foreseeably injure third parties. There could be a duty to those third parties that are injured, even if there isn't a user, bystander, or consumer that you would need to maintain a strict products liability action. And I mean, and negligence has certain advantages, right? You don't need to establish the plaintiff that the defendant is in the business of selling the product. As we just discussed, there's not a per se limit on whom the plaintiffs may sue. We see that in the Worrell case that's cited in the Amundsen case, the Hiles Company case, and in Shoshone. And the limit for negligence cases is traditional negligence concepts of duty and proximate cause. And that gets into certain policy considerations for that are proportionate to the finding of fault of the defendant, i.e. the defendant's failure to exercise ordinary care. So the only hurdle that a plaintiff has in a negligence action is that they have to show, well, they do have to show proximate cause, which does involve a foreseeability analysis, and they have to show that the defendant failed to exercise the standard of care required under the circumstances. But if you're suing in strict products liability, I mean, there's a reason why it's called strict liability, and it's not just because the plaintiffs don't have to prove fault. If you're going to recover against the fault-free defendant, then you need a limitation on the plaintiffs that are going to sue. And that limitation is found in section 402A itself. And it's found in the fact that Ms. Lowell and I couldn't find any cases where a plaintiff who doesn't actually interact with the allegedly defective product itself cannot recover under a strict liability theory. That's why in restatement, in the section 402A comment O, it talks about the bystanders and others who may come in contact with the product. Now, you mentioned a little bit earlier, well, okay, but isn't there a question about, maybe there just is one product, right? It's the real water product, and isn't, in some sense, Milwaukee a co-manufacturer of that product? But the answer is no, because nothing that Milwaukee manufactured was incorporated as a component part or otherwise into the real water product.
But when you say or otherwise, it was we can all agree on this one fact, it was utilized during the manufacturing processes, right?
Yeah, just as a company probably, would have a Microsoft Office suite that they use to do designs and to send memos and stuff. But there's no question that, Microsoft wouldn't be brought in as a products liability defendant in every case where the products manufactured by that company proved to be defective. And if the answer to that is, yeah, but that's Microsoft.
No, my answer to that would be slightly different. It would be, for what purpose is the software being utilized?
In other words, looking at the state of mind of the
No, not at
manufacturer.
all. For what purpose is the software being utilized? And I will admit, I'm not a software guy. I know nothing about coding or any of that type of issue. But say hypothetically, you were relying upon a major software manufacturer to give you specific specifications that are utilized during the manufacturing processes and are relied upon by the manufacturer. And ultimately it results in a defective product. Under those circumstances, with the software writer that and the coding that was utilized as part of the manufacturing process, would they be immune from liability under a strict products liability clause claim for relief? Which is fascinating.
Well, let me answer that in two parts. One, actually three parts. One, I confess I don't know whether code constitutes a product, but let's assume that it does, the computer code.
But see, I'm not saying code. I mean, code. Typically, we look at code. It comes under coding comes under what is it? NRS 600A, right?
Trade secrets.
Yeah,
I was just arguing that on Friday.
Yeah. It's funny what you learn as a trial judge doing business court and all these different areas. But I'm looking at it more specifically as being part of the manufacturing processes. That's the thrust.
And we could say whether it's software or a widget that's used in the manufacturing process, but that isn't incorporated into the final product. So I have two answers. One is the manufacturer.
And the manufacturer knew that whatever its product or meter or something like that was being used as part of the processes. Because you have to remember what's fascinating about this case and so on, and we kind of overlooked this, but it was the basis for the claim asserted by the plaintiff as it pertains to the manufacturer and your client and the use of the product, because they were focusing on the instructions, right, or lack thereof, and that's my recollection. That was one of the key reasons why they were in the case. But go ahead.
Well, and right, and in our case, we weren't, of course, talking about instructions to the drinkers of real water. We're not talking about just we're talking about instructions that would go to real water.
Yes.
Right. With real water being the end user of our product, right? Real water is a separate product that uses our product in the course of manufacturing real water. But that doesn't change real water. That doesn't make the meter a product that gets integrated into real water. It's still the meter that stays in the warehouse and never goes to the drinkers of real water. So, and it's interesting that you mentioned that, yeah, but Milwaukee knew that its product was being used for this purpose. Number one, well, we did get the jury did find for us on the punitive damages claim. But number two,
we know why. Potentially that can go to there's a different standard of proof for punitive damages. Right?
I'll grant that. But even assuming that Milwaukee knew that its product was being used for this particular purpose and that it had the potential to harm plaintiffs, well, that would give plaintiffs perhaps a remedy in negligence. But it doesn't create a remedy in strict products liability.
Actually,
I don't think it gets any clearer than.
You have a really good record.
I think I do too, Your Honor. So I'm happy to move on.
No, that's okay. Mr. Polsenberg wants to jump in and add something.
I'm gonna ruin the record.
We have a really good record.
That's all right. I'll sit there.
No.
What do you want to add, Mr. Posenberg?
I think, Judge, you're trying to take the concept of products liability and stretch it way beyond its intent. And I think Nevada in Ford versus Trejo, Trejo, is saying that they are sticking with restatement second, old school products liability. And you brought up the J.C. Penney case. And that's McCourt versus J.C. Penney, and that is the case that really talks about old school products liability. What could be more a product than Shora McCourt's pajamas? And her name is spelled Joera. And there it was, the defense coming in saying, oh, we tried everything we could.
We did everything we can. This thing was been washed 150, 200 times.
Nobody likes flame-proof pajamas. And the Supreme Court said, well, the jury should have felt the pajamas and decided for themselves. Focusing on the product. You are moving further and further away from the product if you're talking about the machine that makes the product rather than the entity that owns the machine that makes the product, whether you're talking about the building where the product is made, the land that it's on. I mean, you're taking Paul's graph concepts and throwing them out the window. There's got to be a line that we draw.
Well, Mr. Posenberg, respectfully, I disagree with your Paul's graph analysis there, because I'm not talking about the building. I'm not talking about any of those issues. I'm talking about real water, and it's a defective product, right? And they admitted to liability. I'm talking about the components or potential involvement of your client in the manufacturing of the product. That's all I'm talking about. I'm not talking about the mouse traps. I'm not talking about the building. I'm not going far afield from that. I'm talking about the manufacturing process. And it's my recollection, there was testimony during the course and scope of this trial that your client knew that this was part of the manufacturing.
You're bringing up facts, but the whole idea of products liability is to get away from those facts. You're going to expand products liability because, well, in this case, somebody who made part of the machinery, and you keep saying component part. We weren't a component part. Component means you're part of the actual product. But you're drawing these, it's like.
Why isn't it part of the actual product when it's being utilized, making a determination as to whether the alkaline levels of the water have reached the specifications that real water wanted the water to be, I guess, presented or sold to the consumer?
What we made did not become part of the product. I've been in a lot of component part cases. I used to do with the wonderful Drake, Illinois. I used to do GM cases. And yeah, every manufacturer of every little part of that, but it was part of that.
Explain to me why it's not part of it.
It isn't, because it's not part of it. You got to draw a line, Judge. Just something that's used to make a product isn't the product. And if you keep drawing these, this is the discussion we got into last time we were here on this case. You're trying to make factual issues that totally, I mean, if we're going to look at that kind of factual issue, the Nevada Supreme Court would have gone to the risk benefit analysis.
Well, I don't know if that's necessarily true. But my point is this, at the end of the day, I hope all my decisions are made based upon certain facts, and I just don't make it. You see, I mean, everything has to be tethered to facts. And so this is a unique issue. You're saying, look, Judge, notwithstanding the fact that this ORT meter was part of the manufacturing process, that you feel that based upon strict products liability law, the plaintiffs in this case should not have an avenue of recovery under the restatement of torts flow 2A.
Right.
That's what you're saying. I mean,
That is what I'm saying, and let me draw a distinction. Because Abe's right. Plaintiffs could have sued us in negligence. Now, I know Will doesn't like suing in negligence. He wants the much easier case of suing in strict liability. But he'd need to make out a case in negligence to sue Milwaukee. Or he could have skipped us entirely. He could have sued Real Water. Heck, Real Water even conceded liability. Real Water has a different set of rights against us. I mean, they may even have contractual indemnity under the facts of this case. But that is different from the broad-based idea of strict liability to consumers. And that, I think, does not apply here.
I understand.
Thank you.
I get it. Anyone else wanted, anybody else part of this? I think this is it, right? Mr. Kemp.
Yeah, Judge, I break this down into three areas: foreseeability, privity, and their argument that there should be some limitation for users and consumers. So let's talk about foreseeability first of all. They've already conceded they're not making a foreseeability argument. And I think you can, there's still foreseeability in product cases, and I'd cite Price versus Blaine. That's the George W. Bush mass tipping case where they held that it's an intervening and superseding cause if the manufacturer can't foresee that his product's being used in a certain way. So I think there's still some foreseeability left.
I understand.
Yeah, but so they're not arguing foreseeability, and the reason they're not arguing foreseeability is we have the two emails in the product literature that the court referred to. We have the email from one customer that says, "What should I use when I'm making drinking water?" And Mr. Brown, Jason Brown, says, "I recommend the MW500 for ORP." And then he says, "Quote, I have tons of Kangen water customers. The go-to ORP portable is the MW500. So for this specific usage, making alkaline or Kangen water, he recommends this is the quote go-to meter." Then it gets worse for them. Another email. "Okay, will the MW500 be suitable for testing water? I have a Kangen water machine." And he says, "Yes, it is." So now he says fitness. And then it really gets bad for him because we attach the product literature that says that if you don't use the ORP meter properly, you could have problems with water quality. So they clearly foresaw the potential problem, the exact problem in this case. Maybe they didn't foresee hydrazine, but they foresaw that if the ORP meter wasn't working properly, you could have a quality problem with the water. So there's really no foreseeability argument. So what we have left is privity and this limitation to users and consumers. So the privity, the Professor Prosser wrote his article in 1965. That was what, 59 years ago, and we still have the defense bar bringing up privity as a requirement. You look at the Nevada Supreme Court cases, none of them require privity. Except the old ones that they're relying on, the Long case, which is a 1963 case, 61 years ago, and the other case that was mentioned, which is a 50-year-old case. Those are the cases relying upon privity. When you look at the more recent decisions, and we cite at length Justice Beulah's decision in ADART, A-D-A-R-T, and she goes on and on about this issue. Quote, "And in 1960, the New Jersey Supreme Court eliminated the privity rule in warranty cases altogether, holding that an implied warranty claim could survive absent privity and despite a manufacturer disclaimer." We have no disclaimer in this case. I point that out for the record. And then she goes on and she talks about the policy rationale, saying, quote, "Although policy rationales underpinning the doctrine," and that's the doctrine for privity, "doctrine vary to one degree or another, they are generally consistent and always have the consumer or ultimate user's ability to recover in mind." So that is the objective of the Nevada Supreme Court and the appellate court, consumer recovery. And then she says again, the rationales are generally well-defined, consistent, and aimed at protecting users and consumers by providing an avenue of recovery for losses sustained as a result of defective product. That's the policy that our appellate court has endorsed. And that's also the policy that Justice Stiglitz endorsed in Trejo. So that's where we start on this privity analysis. Now they say there's a privity requirement. There's not. There's no basis for them saying that there's privity requirement. There's no case so holding except these old cases. There's these appellate cases that are expressly against that. So to argue in this day and age, in the year 2024, that you can't recover on an implied warranty claim because there's no privity, I just don't think there's any support for that. So that's the privity issue. Moving over to the limitation they want on users and consumers. Okay, so they say, all right, we're a restatement second jurisdiction because Justice Stiglitz in the Trejo case rejected the restatement third. And so now they're saying that, well, even in a restatement second district, that you should adopt this user or consumer limitation. Well, I'd start out by the fact that the editors of the restatement explicitly state that they have not taken a position on that. And I'm quoting from the Dumas case. I think, Dubas. Yeah, I'm getting my cases mixed up. Your Honor, that's a real fascinating case. That's a 2021 case. It comes out of Nebraska, Federal District Court, talks about a lot of these issues. But on this particular issue, reading from the Dumas case, turning to the language of the restatement second, upon which Clark Equipment, that's the defendant in the position of Milwaukee in this case, relies, while 402A itself refers to harm to consumers, the section is limited by the following caveat, quote, the Institute, and that's the Institute that publishes the restatement, the Institute expresses no opinion as to whether the rules applied in this section may not apply, one, to harm to persons other than users or consumers, unquote. So the restatement left it as an open issue. Now we get to the Dubas case. The Dubas case specifically held, and again, this is Nebraska law, this is Nevada law, but it specifically held that there's no user or consumer limitation, and that if it's an injured bystander, you can sue for recovery. So the question is, what would Nevada do under like circumstances? I think the Chiabani case tells us exactly what Nevada would do. Chiabani is the case where the bus went by the guy on the bicycle, and there was an argument that there was a failure to warn to the driver by the bus manufacturer of the propensity, the air blast propensity of the boxy coach design that they did. And so that was a pure bystander case. You know, Dr. Chiabani, the person on the bicycle, he wasn't a driver of the bus. He wasn't a passenger of the bus. He was a pure bystander. And the court allowed recovery in that case. True, there's not an extensive discussion of the rationale for that in the case, but there is an allowance of recovery. So we have to look at what would the court do in this particular case. Would it follow the Dubas approach, allowing maximum recovery by a consumer? Or would it go back to some sort of has to touch the injured victim or some sort of privity requirement? And I would submit that based upon the language in Trejo, that they're doing this to expand recovery for the consumer, and also the language that I read from Adart, that the primary goal is to expand recovery for an injured consumer, that our court is going to hold that there is no basis for a limitation to users or consumers as the defendants urge. So for those reasons, we submit that the motion should be denied. Thank you.
Okay, thank you. And we'll give the defense the last word.
Thank you, Your Honor. I guess I'll start with the last point, the Dubas case, which is a great explication of how why a court following the second restatement might want to expand the class of plaintiffs to bystanders. And in that case, Mr. Dubas was run over by a Bobcat loader. He contacted the product directly, just as the plaintiff in Chiabani, or I'm sorry, Mr. Chiabani, Dr. Chiabani, contacted the motor coach. So there was actually direct contact with the product, precisely in the way that comment O to section 402A says, right? And so again, although they did cite this quote extensively from the Dubas case, that's not a case that involves a plaintiff who had no contact with the allegedly defective product. Let me address privity. Well, actually, let me foreseeability, since that's related to the issue of strict products liability. Now, in their opposition, I believe they only cited to the water tester website. So they're citing new things in their argument. That's fine. Regardless, I think we're talking past each other when we're discussing this foreseeability analysis. They cite the Price case, which is a superseding intervening cause case. Yeah, foreseeability is an element in two parts of a negligence case. It's at the initial stage of duty, establishing the duties, as in the horse Clark County versus Ashwood versus Clark County, where there may be a foreseeability element even in establishing to whom the defendant owes a duty. And then there's a separate foreseeability analysis that comes in at the causation stage. Was this injury a reasonably foreseeable, or was this injury foreseeably caused by the defendant's negligence? And I don't dispute that you still have to prove causation in strict products liability case. But the issue is when we're talking about the duty of a manufacturer of a product, to whom does that duty run? Well, the doctrine of strict products
Doesn't
liability.
it ultimately depend on, and tell me why this isn't important. If the manufacturer of the product knows that the particular use upon which that product will be utilized, what impact does that have? Because that appears to be one of the big issues in this case, because we have testimony. And I know Mr. Polsenberg said, well, Judge, don't rely upon the facts. That's what I try to rely upon, the facts, right? We have testimony in this case that was uncontroverted as to the use of the ORP meter, right? And it was saying, look, this ORP meter, and I don't want to paraphrase or get anything out of as to particularities as to specifically what was said in emails and also by the representative. But they knew that it was going to be utilized for this purpose, right? And so can't we all agree on this one fact that the ORP meters were part of the manufacturing process, right?
I don't think we're disputing that the meters were part of the manufacturing process. What we're talking about is whether that suffices to make them a component part of of the real water product. And I mean, the definition in ADART, Schuler versus ADART, is whether it becomes indivisibly.
That's really fascinating, because when you really crystallize what happened here, the ORP meters were being utilized as part of the manufacturing processes.
Or the process, yeah.
Yeah, with their knowledge, which is fascinating, right? This isn't a situation where they apparently didn't know that this product was being utilized for that purpose. They had actual knowledge of it. It was being utilized for the manufacturing of alkaline and Kangen water from a testing perspective, which is really fascinating, right?
Yeah, and so the question then is, would it make any difference if they didn't know? If Milwaukee had no idea that its product was
But see, I don't, that question I don't have to answer.
You don't have to, well, you don't have to answer that because
Because
of the facts in the case.
I mean, that's why I circle back to the facts,
Yeah,
right?
or at
And
least
so that's, I mean, that might be a different issue for me to answer, but the facts are the facts,
So,
good or bad.
yeah, but the very fact that you're talking about what Milwaukee knew means that we're talking about a theory of liability where the defendant's state of mind is relevant, and that would be a negligence theory.
No, that's not what I'm talking about. I'm just talking about that they actually knew that it was part of the manufacturing process. And here's my point. I kind of come back to, and I don't mind saying it, I really do respect Judge Bulla. And of course, there's a lot of reasons why I have known her forever since I've been in Las Vegas, and we worked together for a long time. And what do I do when she specifically addresses the policy concerns behind strict products liability? And she says the following, quote, although policy rationales underpinning the doctrine vary to one degree or another, they are generally consistent and always have the consumers or ultimate users' ability to recover in mind.
And I agree with what that said, the ultimate consumer or user. Right, or sorry, the word is the consumers or ultimate users' ability to recover.
Right.
And that's the balance that our Supreme Court has stricken in developing this area of the law, right? If we're
And
going
I have
to
a
keep,
question for you. When it comes to the manufacturing processes as it relates to alkaline water, who would be the consumer of the water?
so the consumer of the water product would be the plaintiffs. The
Right.
consumer of the meter product would be the manufacturer of real water, or would be real water.
Do you think that's an artificial distinction? Because
Absolutely not.
okay, but this is my point. I think this is an important point. And understand this, I'm not saying hypothetically that, and I don't want to throw in negligence concepts, but here we have a scenario where the ORC manufacturer knew that their product was being used as part of the manufacturing processes. Right?
I get it that there's conflicting evidence on that, but yeah.
No, I don't think there was much of a conflict of evidence on that because those were admissions, right? And I think this is a really important point. I do, because I kind of get where you're going, but at the end of the day, it appears to me they knew that the ORC meter was being utilized as part of the manufacturing processes, right? And so you say, well, manufacturing processes. Well, what was being manufactured? Alkaline water being sold to the public, right? And ultimately, who was the consumer of the alkaline water? That would have been the plaintiffs in this case. Now, I understand what you're saying, and you're saying, look, Judge, no, under the facts of this case, the consumer should be, as it relates to the ORC meter, real water. I get that. I understand what your position is, but then I look at it slightly differently. That's all. I mean, I understand. I think the record's really developed in that regard.
And it will be interesting to see what the Supreme Court does, considering this would be the first case to expand products liability in that manner. To have somebody who hasn't even touched or interacted with the product, the meter product, to nonetheless have a claim, not just in negligence, but in strict liability.
Well, I guess it comes down to how you define interact with the metered product, because ultimately the water that was consumed, and there's a nexus there, because the ORC meters were being utilized for the purpose of determining, and this is my recollection, the pH levels of the water that were involved in being sold to consumers. You know?
But my worry from, and obviously I'm representing a client here, but my worry just from a jurisprudence or a philosophical standpoint, if that's what products liability means, then anytime you have, an electrical surge within the facility, the manufacturing facility, now the electric utility is potentially a defendant in a products liability case. Every time there's a bug in Microsoft Office, Microsoft is potentially a defendant in a products liability case, simply because there are people who employed by the actual manufacturer of the end product, the real waters of the world, that utilize products by all sorts of people. And now we're going to say that any one of those manufacturers of a product that goes into simply the process of manufacturing a product, that any one of them could now be dragged into court on a strict products liability theory. Not, again, negligence is always available to reach those that cause harm, and it's not limited to consumers or users, the way that Judge Bullitt pointed out in the Adart case. So the Supreme Court's going to have to take up this question, but I do think it's a novel issue. Let me just make one last point on the privity point. I guess we're accused of citing old cases, even though the Hiles Company case in footnote 5 itself makes clear that Amundsen and Long are not bad law. They were just talking about horizontal privity rather than vertical privity. But to the extent we need to look beyond that, from 2023, the Federal District Court in Hernandez versus Home Depot Company. This is 2023 Westlaw 8775685. Sorry, let me start over. 2023 Westlaw 8775861. They cite the Amundsen case in a breach of warranty claim, reiterate the holding from Amundsen in Nevada, unless there's privity, liability to the consumer must be in tort and not in contract. In the Ninth Circuit in 2020, 837 Federal Appendix 472, Miller versus Dupuy, DEPUI, again reiterates that the holding from Amundsen, that Nevada law does not allow an implied warranty claim in the absence of privity between the parties. So privity is still a live concept, and certainly there's nothing in the development of the case law since the 1970s that has abolished the plain text of NRS 104-1823. 2318, sorry, apologize for my dyslexia there, or whatever it is when you mix up numbers. So privity is still alive and well, even though the Hiles Company case talked about remote buyers potentially having a warranty claim. You still need a buyer. You need a buyer of the product. And here we do not, these plaintiffs are not buyers of the meter. So they're not in privity for a breach of warranty claim. And the fact that they're relying on these products liability cases to establish that, oh, well, you know, the law in this area has evolved, I think only underscores why it was unfair for them not to plead that claim and to bring it up and to get 15B relief for that claim. Let me just make sure I haven't missed anything.
No, take your time, because I have a comment, and I think this is overlooked. And this is why facts are important in this case.
Oh, yeah, just one other point. I mean, in the ad art case, the Urschuler, I think Judge Bulla there was actually recognizing the problems with a warranty theory. She says that warranty theories of recovery reintroduced the privity problem. So she's recognizing that warranty does require privity. She then describes how other states dealt with the issue, such as New Jersey's elimination of privity requirements and warranty claims. But that was all predating the adoption of the UCC in Nevada in 1963 or 1965. And there's no question that Nevada took a different approach, right? We didn't adopt alternative C of the Uniform Act. We adopted alternative A that requires the family or household relationship. So allowing a claim of strict products liability separate from the UCC breach of warranty claim just means that the breach of warranty claim has a stricter standing requirement. I think that's all I have, Your Honor. Thank you.
Okay. Ma'am, I don't want to overlook you. Anything else you wanted to add?
Your Honor, I would just say, you have the final word on what claim was added under Rule 15B, whether it was a UCC claim or not a UCC claim. Or we can leave it the way it is and the Supreme Court will do what they do. Okay, thank you, Your Honor.
Right, best way to do it. Mr. Reynolds, sir.
Thank you, Your Honor. Joe Reynolds, for the record, on behalf of Hanna Instruments. Before the court makes any decision, I'd just like to reflect on the record that Hanna joins in and concurs with the arguments of Milwaukee's counsel, both in their 50B motion and the arguments made today, and preserves those as its own. Thank you.
All right. And this is what I'm going to do. And I just have something to point out, and I think this is important. And it really goes to the factual issues as far as the record and how it's developed and how Milwaukee will have actual knowledge of the product use for as far as the orb meter is concerned. And it was part of the manufacturing processes resulting in alkaline and or Kangen type water. And I think this is really kind of important because, say, hypothetically, if they had no knowledge of it and they felt that, you know what, that this shouldn't have been used for this particular purpose, then they potentially could have had a defense of product misuse, right? They could have, and which would have been a viable defense, because I think that's often overlooked when it comes to products liability. So what I'm going to do is this, and this is a fascinating issue. I'm focusing on the fact that, and my decision is based upon the usage of the ORT meter at issue. There's no surprise it wasn't actually just known, but it was encouraged. Go ahead, Mr. Polsenberg.
Your Honor, you raised misuse, and so I have to ask, even more than rhetorically, misuse by whom?
Well,
Because it would be, if we raised it as a defense, it would be a defense against product, against the plaintiffs.
oh yeah, but I mean,
But they
absolutely.
didn't use it or misuse it.
Oh, no, but I'm not talking about the plaintiffs. I'm talking about, because this is your argument. You're saying, look, Judge, under the facts of this case, the end user it would have to be real water. You're saying, look, they were using the product, and hypothetically, and I'm just pointing out the fact that if Milwaukee didn't know about the usage by real water as it pertains to the ORT meter and being part of the manufacturing processes, then they could sit back and say, wait a second, Judge, we never intended for this product to be even utilized as part of the alkaline water manufacturing process by real water. In contrast, they knew about it and encouraged it.
But misuse is a defense against the plaintiffs. And this, I think, illustrates where you and I don't see eye to eye. We couldn't use misuse because the plaintiffs weren't the user of our product. If you're talking about we use misuse, a claim against real water, maybe not. And the problem,
Well, that's where I'm
this is
at.
part of the problem I have with the 15B issue, where we're assuming we had notice of everything that we could raise. But I mean, my relationship with real water is different in kind from the claims that plaintiffs are bringing against.
But here's my point. Hypothetically, and this is something you'll have to do research on, but it appears to me that if Milwaukee had no knowledge of the usage of this product, i.e. the ORT meters and the manufacturing of real water, potentially that could be a viable defense as to everyone, right? But under the facts of this case, not only did they know about it, but they encouraged it.
Well,
right? And
I think I've made my record on why misuse just makes my point that plaintiffs shouldn't be suing us and products liability.
I understand that. I mean, that's your position, but I mean, I think that's looking at it in a black and white way. I don't think that's looking at it realistically, because hypothetically, if they didn't know their product was being utilized for this purpose, it was never designed for that purpose, and so on, maybe. But on the flip side, and this is what we do know, they had actual knowledge of the usage and they encouraged it, right? And so it was part of the integral manufacturing process, because real water relied upon it when it came to readings, and they knew it. But anyway, and at the end of the day, as it relates to these types of claims, and I guess and this is something we can't overlook, was the policy considerations in general as to the restatement of torts 402A. And I'm focusing on the consumer and our ultimate users. And when I'm talking about that, I'm talking about the members of the public that were drinking real water and their impact on their ability to recovery. And so as far as the motion is concerned, I'm denying that. And we have a good record, and we'll see what happens up above.
Thank you, Your Honor.
Thank you, Your Honor.
Do you
So what do
want to
we
take a break before we do the next one?
Yes. All right, that's what we'll do. It's 3:00. Yeah, we should. And what's next up?
59, motion called for an amendment judgment, which was interest and offset.
So there's no way we're gonna get done today.
Well, didn't we do offset already? We're doing
We
offset.
started this.
We spent-
We didn't do 1298, that's the one.
Okay,
We
let's take,
did the whole offset, did we not?
so after this, how many more do we have after this? I mean, we have quite a bit.
And then we had fees.
So there's two Hanna motions, but I understand they're being rolled into one, so. Also, we have, two defense motions. We're gonna submit the motion tax costs, without argument to the court unless the court needs any clarification, and then we have the motion for fee.
Your Honor, we have Hannah's motion for judgment as a matter of law and also Hannah's motion to amend the judgment.
I understand. Thank you. We'll do it as we can and take one last one. All right, let's go ahead and take a break.
Thank you, Ron.
Okay, we can go back on the record. And so what's up next?
Your Honor, I believe this is Hannah's 50B motion for a renewed motion for a judgment as a matter of law, which is 1292.
Thank you, sir. Let me pull it real quick. Mr. Reynolds, sir, you have the floor.
Thank you, Your Honor. For the most part, Your Honor, Hanna submits its renewed motion on the pleadings on the motion itself, as well as its reply in the record, and as previously stated with Milwaukee's arguments with respect to their 50B motion. Hanna joins and incorporates those arguments as its own, especially with respect to the failure of Warren in the causation. A few points, though, I'd like to put on the record and emphasize for the court's consideration with respects to Hanna's motion. First, Hanna's motion is not moot. Plaintiffs asserted in their opposition that Hanna's 50B motion is moot. Hanna certainly disputes that, and to the extent it is viewed as moot, Hanna submits that it underscores the prejudice with respect to this court's imposition of sanctions against it. As argued and our 50B motion dovetails and is incorporated into our motion for a new trial, and so won't repeat those arguments that were made at the previous hearing.
I understand. I do.
We submit to this court, though, that this court's sanctions order violated Hanna's due process rights, both under the Nevada and the United States Constitution, in that it imposed liability, which was a factual determination that should have gone to the jury, and instead was effectively directed by this court as an instruction. We submit to this court that violated, again, Hanna's due process rights and constitutional rights. Also we submit and have previously made this argument in this court's decision respectfully. The court should have held an evidentiary hearing in this, and had the court held an evidentiary hearing, Hanna proffers that testimony would have been placed on the record from Dr. Salvaggio, as well as Miss Laura Brown, that would not have supported the sanctions that were imposed by this court. As argued by Milwaukee in their 50B motion, there's no evidence, Your Honor, in the record that the plaintiffs used, owned, or consumed an MW 500 meter. As such, Hanna requests that this court grant its motion, that there is not only insufficient evidence, but no evidence sufficient to support the verdict in this case. And with that, we'll submit it to the court.
Thank you, sir. Mr. Kemp.
Your Honor, first of all, procedurally, the previous motion, and this is supposed to be renewal of that motion. The previous motion was entitled Motion for Judgment Number 2 as a matter of law pursuant to NRCB Rule 50 regarding plaintiff's 6 cause of action for inadequate instructions. Unquote. When you look at the argument section, it is 25 lines long, less than 1 full page. Doesn't make any of the arguments they're trying to incorporate from Milwaukee. The only argument it made was with regards to the tip card. It argued there that the tip card gave an adequate warning as a matter of law. Our position on that is, the tip card's not the warning manual. The warning manual didn't say anything about how to oxidize the meter. The tip card wasn't even right. The tip card says 48 hours, not 5 days. The tip card's a piece of 3x5 paper that they put in there. And they argued that fully to the jury that the tip card was adequate in their view, and the jury rejected that argument. And then the other problem with tip card is it didn't warn about the actual hazard in the case, which was if you didn't oxidize the meter, it would give inconsistent readings. So for those reasons, we don't think the tip card argument had any merit, but that was the only argument asserted in the previous Rule 50 motion. In this new rule, in this new motion, which is supposed to be renewed motion, they argued that Dr. Motley's not qualified. Dr. Motley was qualified. His testimony is relatively brief, 3 minutes and 46 seconds. Basically, their warnings expert, Dr. Fordenbaugh, admitted pretty much everything that Dr. Motley said anyway. So for those reasons, we don't think their argument that tip card was the end all be all in merited judgment in their favor has any merit. On the sanctions, I would reincorporate our previous discussion of the sanctions. I don't see the need to go into that. And so for those reasons, we think this should be denied. Thank you, Ron.
Okay, thank you, sir.
Your Honor, Joe Reynolds for the record. I'd point the court attention to footnote 1 on page 5 of our reply. Our arguments that we raised in our renewed motion are properly before this court. One, we timely joined Milwaukee's motion under the 8th Judicial District Court rules. And 2, we also, to the extent that any arguments are being raised new, they are being raised under plain error. And it is appropriate for this court to consider them under the constitutional plain error standard. So they are properly incorporated in the record, and they are properly being raised. With respect to the plaintiff's argument about the tip card, I'll go back to where is the evidence that the plaintiffs read the tip card? And with that, Your Honor, we ask that the court grant Hanna's motion. Thank you.
Okay, just a couple of comments, more specifically addressing, I guess, the due process issues. And I think it's important to point out that under our system of jurisprudence, there's obligations from both parties as it relates to evidence, and the evidence produced and identified pursuant to 16.1 and the like. And I think this is an important issue, an issue as well. Judge, you should have had a evidentiary hearing as it related to the testing. But, we were in trial. I don't know if we were week 4, week 3 or whatever. And these cases are very difficult, number one, to manage from the very beginning of the litigation process until ultimate conclusion by the jury. And so from a due process perspective, due process mandated that the defendant in this case, that there was testing. The testing isn't identified during direct and or cross-examination witnesses. The testing should have been produced a long time prior thereto, and whether the testing was beneficial, whether it wasn't beneficial, we'll never know because the testing wasn't produced. And so anyway, and that goes to the sanction issue. As far as the other issues and as it relates to the Rule 50 motion, I'm going to answer. I think the record's pretty clear. Let's move on to the next one.
Yes, Your Honor, we've agreed to address the fees motion with the understanding that we can't apply whatever the court's determination is on fees, if any, until we resolve the interest issue, because we won't know what the exact interest is.
So what we've agreed to do is to do the, my motion to alter and amend and Hannah's motion to alter and amend, having to do with interest and offset on another day, so that Eric doesn't have to stay on. Is he gone?
I think it's already gone.
All right, so that,
And that's fine.
great, thank you, Your Honor.
Whatever you want to do is okay with me.
Your Honor, the fee motion is pretty simple. We made offers of judgment to Milwaukee for 3 million. We made Hanna 6 million. The real water won't.
And what's the number for that one, Mr. Kemp?
Ultimately, I think, you mean, what was the verdict?
No.
1281.
1280.
Oh, I'm sorry, Your Honor.
It just helps.
Yeah,
The
1280.
numbers finding things, right? Thank you, Mike. And that's plaintiff's motion for attorney's fees, costs, and interest.
So we set forth in our motion, the amounts of the offers of judgment, like I said, Milwaukee. I believe it was 3 million, Hanna was 6 million. In the Gallagher case alone, we offered to settle 3 Gallagher plaintiffs for 500 million. The ultimate verdict was 7 million. Mr. Yu offered to settle for 250,000. The ultimate verdict was 5 million. So I don't think there's any dispute that the offers of judgment were below the ultimate verdict. In fact, they were way below the ultimate verdict, which I think kind of indicates in and of itself that they were unreasonable. The rejection of them was unreasonable. They basically take the position in this case that if they have inadequate insurance, that they can reject every offer of judgment made because they don't have to pay anything. I mean, that's the basic contention here. And they call that, quote, the insurance implications factor. And that there's 20 similar cases, 20 other cases, where there's nothing in the rules or the case law that says an insurance company pays nothing if there's a lot of victims. Okay. And I mean, in this case itself, Real Water didn't take that position because Mr. Haley and the Gallaghers made the $250,000 offer of judgment to Real Water, which they accepted. So the insurance company wasn't a problem when the offer was so low that they thought they had to take it. But when it went up to $250,000, the exact same amount for Mr. Yu, they rejected. And I just don't think that's appropriate. So with regards to the first point, we clearly beat all the offers of judgment. Okay, now they talk about the 40%, and I mean, basically that's a relatively new case from Supreme Court, the Capriati case. I think that was Mr. Prince's case, and it says that the 40% fee doesn't vest until you get the verdict, which doesn't. It says 40% is reasonable, and says the court can award 40%, and I see no. So their argument is, oh, well, you can use this 40% rule in small cases and medium-sized cases, but you can't do it in big cases because it's just too much money. That is just not, that violates the entire reason for the offer of judgment, which is to encourage settlements. So we have offers of judgments to encourage settlement in small and medium cases, but not in big cases. And so I don't think that's an appropriate argument. There's some reference in here that Real Water thinks the offer of judgment shouldn't apply to punitive damages. That's part of the claim, Your Honor. I don't, why shouldn't it apply to punitive damages? So the sanction, the 40% should apply to punitive damages. 40% of 200 million is 80 million. That's what it should be. And 40% of whatever the compensatory verdicts for every year. But I think when you take a look at this, you step back and you look at the policy consideration here. And again, the policy of this offer of judgment statute and rule is to encourage settlements. So you're gonna, their position is that we have exceedingly low offers that are exceeded by the actual verdicts by quite a bit. And under those circumstances, you shouldn't have the attorney's fees apply. I just think that there's no support for that, and it's directly contrary to the policy consideration. And so for those reasons, Your Honor, we'd ask that the motion be granted and we'd be awarded the 40% contingent fee. Thank you, Your Honor.
Thank you, sir. Let's hear from the opposition.
Thank you, Your Honor. I'll jump in first. Joel Odou on behalf of the real water defendants. Your Honor, where I'd like to start is a point of clarification for the court, because I don't think it's clear in the motion. The plaintiffs are seeking a 40% contingency fee for the compensatory damages awards for Orion Gallagher, Camille Gallagher, Brian Gallagher, and Keith Haley. I think the plaintiff just said it. I just want to make sure that the court understands that those claims were settled as to real water. And so for the 40% contingency fees for those plaintiffs, plaintiff appears not to be seeking them because of the settlement. It just, the record looked a little null to us. And so we wanted to make sure it's absolutely clear when if the court's looking at page 5 of the original motion for fees, that those items would only be applicable to the meter defendants. And they say that in their pleading, but you know, as a defense attorney, you'd like it to be very crystal clear. And so
we're and you're just pointing me for the record to page 5 of the motion, I guess, starting at line 17 on down. Is that?
yes, Your Honor. And the way the motion is worded might be a little bit confusing to somebody who's not familiar with the case. I'm sure the court is very familiar with the case, but just to make the record crystal clear, it says an award of plaintiffs post-offer attorney's fees based on the entirety of their 40% contingency fee against defendants Hanna, Milwaukee, and Real Water as applicable. And that's the key language they used. And the total amount combined of 15 million and change. And so we wanted the court to be very clear that the as applicable means it's not applicable to Real Water, because then they go on later on in the motion to calculate it. And so we just wanted to, I'm pretty sure we have an agreement with plaintiffs on this. I just wanted to be very crystal clear for the record that it's about, I don't know, 4.6 million roughly in attorney's fees. Because we didn't do a very good job, I'll be very candid, in our opposition to make it clear that they're not seeking those from us, but they're not. And that's been the agreement of the parties. And it's part of the offers of judgment that were accepted. And so I'd like to then kind of turn to the offers of judgment that were accepted and talk a little bit about the offers of judgment, because I think that really is what is so interesting here. And in particular, the offers of judgment for Baby Gallagher and for the Gallagher family and for Keith Haley were accepted at a time when there was the ability to accept it. And we've gone through in great detail as to why Real Water didn't have the ability to accept the offers of judgment, and the ability to accept the offers of judgment obviously was contingent upon there being money to do so. And in our declination, in explaining to the plaintiffs why we couldn't accept the Belsky offer of judgment, it's attached as I think exhibit 2 or B to our opposition. I believe it's B. No, I'm sorry, it's switch glasses. I think it's C or D. So as part of exhibit C, we attached a letter that we think is very key to the court's discussion. It's April 24, 2023 that we sent to the plaintiffs about the Mr. Belsky $2 million offer of judgment. And in that $2 million offer of judgment, what we noted was that there at that time, in April of 2023, there were claims being made in excess of the policy limits by way of offers of judgment. There was an offer of judgment from a different plaintiff attorney that calculated out to be about $675,000. You add in the offers of judgment that were pending for Mr. Belsky and with other plaintiff attorneys, it exceeds the policy limits. Now, I understand the plaintiff's argument, which is, hey, tough luck. But that goes to the reasonableness and the timing of the offers of judgment. And if the timing of the offers of judgment is that you have a bankrupt entity and you have limited insurance, and you can't accept those offers of judgment, we would argue that's per se unreasonable. Moreover, as we noted in Exhibit C, and in particular the Belsky response, at the time that the Belsky offer of judgment was made, there was about $12.5 million of medical costs alone for the plaintiffs who had filed lawsuits up and through that date. That number, of course, has continued to grow. And there is no dispute. The majority of the plaintiffs in these lawsuits were injured in the 2020 timeframe, or I would even say 2018 to 2020 timeframe. And there's $1 million of coverage, give or take, in each of those policy years. Some of those policy years have excess coverage of $1 million. The 2018 policy has an excess with AIG, but my point is this, without drawing the court into the weeds, the question ultimately is, were the offers of judgment reasonable when given in light of the fact that Real Water is bankrupt, and in light of the fact that the total number of claims against Real Water now exceed 107, 108 plaintiffs, depending on how you count them, and probably exceed $15-16 million at this point. At this time, when this offer was unable to be accepted, the claims exceeded $12.5 million. And that's only medical costs. And so if we only looked at, forget the liability issues, forget the causation issues, pure medical costs of the claims are well in excess of what the policy amounts were. And so that's why there was a race to the courthouse. And the race to the courthouse was, which case is going to get tried first? The Gallagher case got tried first. And the Gallagher case resulted in a judgment in Mr. Belsky's favor. And one of the issues that this court has under submission is, what is the amount of offset that Real Water gets for the settlement between Mr. Belsky and UNFW? And that's under submission, but it's an important part of this motion, because at some point this court's going to determine that some portion of the amount paid in settlement by UNFW was for compensatory damages, and some portion was paid for punitive damages. And that is a important ruling from this court that the parties need, because of course UNFW is seeking contribution and indemnity, equitable indemnity from Real Water, and there are issues whether they can recover equitable indemnity for punitive damages, among other things. And there's also the issue of, did Mr. Belsky prevail? Plaintiffs will argue and have argued, hey, forget the compensatory damages, just look at the punitive damages. And that's problematic, as we've noted, because of the fact of the bankruptcy, because of the stay. Certainly those are issues before another court with other lawyers, but those are issues that we have in this case. And so just as a threshold matter, there are real questions of, did Mr. Belsky meet the offer of judgment? It appears he did, arguably. And was the timing reasonable? And we would argue on behalf of Real Water, we don't represent the insurance companies, we don't represent the bankruptcy trustee. We would argue on behalf of Real Water, they were not reasonable in time because Real Water had no ability to accept them. Certainly that problem exists for the other plaintiffs as well. But I think for Mr. Belsky, it's a little bit more complicated. One of the arguments that the plaintiffs made in support of their request for attorney's fees of about, and I haven't done the math, it's about $59 million from Real Water once you back out those settlements. One of the arguments they made was, well, Real Water contested liability. They had Mr. Casey Aiken give damaging testimony, et cetera, et cetera. As the court's very well aware, Real Water conceded liability. And that goes to the fact that, frankly, the compensatory damages judgment seemed to be in less than if Real Water had conceded liability in the face of pretty substantial evidence gathered by its co-defendants that went out and tested the water and found hydrazine in the water. So as far as the rejection of the offers of judgment, it certainly wasn't based on the evidence. It was based on, and it certainly could have been, because the evidence was stacked against Real Water. The fact was Real Water was unable to accept these offers of judgment. And then once the courts ruling on various motions of limine came through, certainly it was clear that the co-defendants' defenses also were lacking. So we believe the offers of judgment, which were made well before even Mr. Buskin's deposition, were unreasonable in their time. Plaintiff made an argument that the 40% is just something that the court should bless, and plaintiffs didn't even address the Brunzell or Beatty factors. We think those are very, very important. And those are things that, regardless whether it's a contingency fee or it's an hourly fee, those things have to be addressed by the plaintiffs and by the court. And we walked through some of those factors, and certainly there's no doubt that it's a complicated case. There's no doubt the plaintiff's attorneys are skilled in their profession and they do products liability cases. So we're not calling into question that at all. What we're calling into question is the amount of the attorney's fees award. In the case of Real Water, about 49 million. In the case of the total, it's about 63 million. That is a shocking amount for attorney's fees. Yeah, we believe that the bootstrapping, if you will, of adding attorney's fees to the punitive damages verdict just makes that even more of a shocking amount. Now, certainly the court has heard and declined our motion to reduce the attorney's fees. I'm sorry, to reduce the punitive damages fees, but we believe the attorney's fees should be reduced and to recover basically $48 million of attorney's fees on the punitive damages award shocks the conscience. It's too much. It also raises questions about whether or not that violates the bankruptcy stay. That's an argument for a different court and different law. The relief from stay certainly didn't give the plaintiff permission to get punitive damages from Real Water. And again, well in excess of any insurance that Real Water ever had. We also made arguments about the fact that the problem for the court or for the courts is how do you instruct a jury on punitive damages when you have a bankrupt entity? We've made our record on that. I just wish to note for the record that without any frame of reference as to the size of the company, a punitive damages verdict is based on no evidence. It's based on purely argument. This case, we went from concluding evidence to verdict and then just additional argument because there was no evidence to support the punitive damage award in terms of the size or financial capability of Real Water, even at its best. And I understand the arguments, the plaintiff's counsel, I understand the ultimate ruling of this court was, hey, they're bankrupt, their financial status is irrelevant. We still argue that the financial status at the height of the company was still relevant for the ballpark or the amount of punitive damages, and that the amount was excessive. And then to award attorney's fees on top of the punitive damages award is excessive. Your Honor, I believe the other arguments that we made were in relation to the costs being claimed. There's a memorandum of costs that was filed. There's a motion of tax costs. Plaintiffs have added some additional experts to this motion, which we join in the arguments of the meter defendants that those are improper. Catherine Peck didn't testify in this case. They're seeking her attorney or her expert costs in excess of the statute I'm going to add. And so for those reasons, we would ask the motion to be denied. And I think finally, the amount is a shocking amount when we look at, if there was an hourly rate of $500 an hour. I think by one calculation, it was 16 years or something like that to make that kind of attorney's fee an hourly rate. And we understand, look, this is a contingency fee. Contingency fees by the Nevada Supreme Court are different, and we get that, but they still have to be supported by the Brunzell factors. They still have to be supported by the Beatty factors, and a comparison of how long would it take to make that kind of fee working at $500 an hour is appropriate, and we think the fee is excessive. And for those reasons, we would ask that the court deny the motion and reduce the amount of attorney's fees. Thank you.
Thank you, sir. Up next.
I'll go next. Abe Smith from Milwaukee, and we will join in Real Water's opposition, especially regarding the issue of whether or not the offer of judgment was in fact beaten, for example, with Mr. Belsky, and the 2.6 million award that he got at trial, we've made our argument about apportionment, that there should have been an apportionment of damages under NRS 41-141. I understand your honors rejected our motion to alter our motion for new trial and motion to alter and amend on that basis, but I did just want to preserve that argument. And also this issue of how the offers were structured. Now, I'm probably today not going to go so far as to say that the offers of judgment were invalid in the sense that we couldn't have accepted them, but we do have to look at the reality of how these cases have been structured, how plaintiffs have strategically chosen to bring certain clusters of plaintiffs in some cases and then file different suits for other plaintiffs, so that as a result we have multiple ongoing cases. But these cases are certainly related. They're even formally consolidated for purposes, or coordinated for purposes of discovery. And the offers of judgment in this case were specifically structured to exhaust Milwaukee's insurance for this one case in all of the potential policy years, leaving nothing, if the offers were accepted, nothing in terms of policy, insurance funds available for any of the other plaintiffs in the other cases. And there's no question that if these cases had been joined as a single action, it wouldn't have been an offer in good faith, or at the very least, it wouldn't have been grossly unreasonable to reject an offer that simply sent a policy limits offer to fewer than all of the defendants, or rather an offer exceeding the policy limits to all of the defendants, such that there would be no policy limits left to cover the offers to the remaining defendants. And just as an example here, you've got the offer of judgment that is specifically tied to an insurance policy in a particular policy year, and it has no relation to the actual damages of that particular plaintiff. So Mr. Belsky, for example, even though his medical expenses were just over $37,000, the amount of the offer of judgment was nearly 30 times that, or 27 times that, $1 million. Ms. Haley or Mr. Haley, in his damages of just under 38,000, the amount of the offer of judgment for him was 500,000. Again, 13 times the disclosed medical expenses, and that you can go through each of the plaintiffs that way, but there's no correlation between the amount of the disclosed medical expenses and the amount of the offer. No, I get that they claim, well, but we had general damages. Well, we had this claim for medical monitoring, but you have to look at the offer at the time, or you have to look at the reasonableness of the rejection at the time the offer was made. And at the time the offer was made, all we had was plaintiff 16.1 disclosure from, I believe, March 20th, 2023. And all it has is a computation of damages based on past medical expenses. They don't disclose future medical expenses, which ended up being, in the grand scheme of things, minimal. I think it was 50,000 for medical monitoring expenses, and no disclosure of the general damages that plaintiffs would be seeking. So looking at the offer of judgment from that lens, right at the time we were given it, it was not grossly unreasonable for us to reject that offer. In particular, given the timing of the offer, we had just gotten initial expert disclosures. There was a new theory coming out from plaintiffs that there was this chemical hydrazine that had been introduced into real water. Our rebuttal experts hadn't had an opportunity to produce their reports because our reports weren't due until the end of April 2023. And so we're in this period of flux where we're just learning about new information and not really able to digest or respond to these offers of judgment. I also want to highlight kind of a broader point. In the Yamaha motor case, Yamaha versus Arnold, Arnoult, the Supreme Court's clear that offers of judgment, yes, I'll agree with Mr. Kemp, they're a tool to encourage settlement. But the Yamaha court is also adamant about saying that offers should not have the effect of forcing parties to forego legitimate claims or defenses. And that's why in that case, they actually had to clarify that even though at that time the offer of judgment rule didn't, or I'm sorry, the Beatty case had not specified that the same factors would apply whether you're a defendant making an offer or a plaintiff making an offer. Yamaha clarified that yes, it is the same factors. So in that case, they said, look, the trial court should have taken into account whether Yamaha's defenses were litigated in good faith. If the good faith of either party in litigating liability and or damage issues is not taken into account, offers would have the effect of unfairly forcing litigants to forego legitimate claims. And here, just to address that factor, we absolutely had good faith defenses, both as to liability and as to damage. Even today, we've been talking about the novel issues raised in this case about whether the strict products liability applies to this kind of a claim. Even the plaintiffs haven't been able to find a single case supporting liability to non-bystanders or people that don't have contact with the product. And again, at this time, we did not know that Real Water would be stipulating to liability, which effectively stripped us of any ability to establish a causation defense on there not being hydrazine in the water. And also on liability, the exclusion of our experts that didn't come until well after the offers of judgment expired. And again, from both the offers of judgment themselves, but more importantly, from the 16.1 disclosures, there was no way for us to tell that in a case involving these kinds of medical expenses, the verdict would be in excess of $38 million. So I don't think it was. We did have good faith defenses. We had good faith defenses on liability and on damages, and it was not grossly unreasonable for us to reject the offer, given the information we knew at the time. And just on the issue of the sanction. Now I know Hannah's gonna talk about the sanction issue. In plaintiff's reply, they start to conflate, and I do recognize that they made one motion and each defendant filed a separate opposition, but then they did a combined reply. But they do conflate Real Water, which had stipulated to liability, Hanna, which had the sanction issued against it, with Milwaukee, which did not have a sanction issued against us. So the idea that we were litigating in bad faith or were not, permitted to defend, that's simply not true. We had a good faith defense both on liability and damages. Now, getting to Brunzell, again, I'll adopt Mr. Odou's argument. Just because the plaintiffs themselves agree to a 40% contingency fee does not justify shifting that entire amount to the defendants. The Capriati case does not override the plain language of Rule 68. It still has to be a reasonable fee for the post-offer work. In that case, of course, I think the majority, even though that was a 4-3 decision, I think the majority is pointing out that, well, it's not per se unreasonable simply because you have a contingency fee that the plaintiff needs to pay his or her lawyer only at the end of the case. But the Capriati court was also very clear that this doesn't abrogate the ordinary analysis under Brunzell. We do have to look at the quality of the counsel, the character of the work performed, and the result, all of that. Now, here I do take issue with an award of $15 million for work performed between April 2023 and October 2023. In fact, as a separate issue, we did point out in our opposition that they calculate prejudgment interest based on the offers of judgment in March. They don't actually calculate it as to Milwaukee. So I think they forfeited that argument as to Milwaukee. But regardless, $15 million, that's not a reasonable fee for those months of work. And it is specifically under Rule 68, it is limited to the work performed after the offer of judgment. And just make sure I haven't forgotten anything. Oh, and then, yeah, our final point about the new experts that show up in the motion for attorney's fees, there's no documentation that would justify an award of those fees at all, much less an award in excess of the presumptive statutory minimum. They have not met the requirements under Frazier versus Drake. And the declaration of counsel is not sufficient to establish that. Thank you, Your Honor.
Good afternoon, Your Honor. Just first, I want to put on the record that Hanna also joins the arguments raised by Real Water and Milwaukee here and preserves them as their own. And Your Honor, I'm going to try to focus specifically on the Hanna specific issues that haven't been discussed previously, starting with the third factor of Beatty, which is if the rejection of the offers was grossly unreasonable or in bad faith. Now here, Your Honor, Hanna was served far later than any other defendant. We were served over 2 years into the litigation. 5 months later, Hanna is the first defendant to receive offers of judgment before there are even expert disclosures. So Hanna was faced with, a determination at that time with limited information available to it, whether to accept or refuse the offers of judgment. Now I would submit here that rejection was not grossly unreasonable. And the Supreme Court has defined grossly unreasonable as something which arises much higher than poor judgment or tactics. So here we had limited information. Hanna was 5 months into the case. We get these offers of judgment. It cannot be grossly unreasonable at that time to reject offers based on the limited information that was available. If the court is inclined to nonetheless award attorney's fees against Hanna, however, Your Honor, we submit that the attorney's fees should be apportioned between Real Water, Milwaukee, and Hanna. First, regarding the punitive damages, plaintiffs seem to agree in their brief that any attorney's fees arising from those must obviously lie solely with Real Water, since neither Hanna nor Milwaukee were involved in those punitive damages. However, we maintain that the compensatory damages should also be apportioned. Now, in Gunderson, the Nevada Supreme Court clarified that the decision to apportion NRCP 68 sanctions is within the discretion of the court. However, in Mayfield, the Supreme Court stated that the court must attempt to apportion the attorney's fees and can only avoid doing so if apportionment is impractical. Here, Your Honor, it's not only not impracticable, it is prudent. Now, there are two non-exhaustive factors that the court lays out to determine whether apportionment of attorney's fees is appropriate. First is whether there are distinct issues raised justifying apportionment between the parties. And two, whether the offeror would otherwise not be able to recover a substantial portion of their judgment. Okay. Now, the first factor, Your Honor, weighs heavily in favor of apportionment because, first of all, in regards to the distinction between Real Water and Hanna, I mean, the distinction is night and day. In fact, there were no common causes of action raised between Real Water and Hanna. The bases for liability are different. The damages awarded against the two parties are different. Apportionment between those two parties is very evident. In regards to Hanna and Milwaukee, obviously those parties are a little more interconnected. However, here, Your Honor, I would point to the fact that, one, again, Hanna was served much, much later than Milwaukee. 75% into the life of this litigation was when Hanna was first served. Second, Your Honor, I would point to the fact that when the offers of judgment were made, the amounts of the offers between Hanna and Milwaukee were different for every single plaintiff except one. So clearly, even plaintiffs saw different liabilities between the parties. And so again, given those two distinctions, apportionment between Hanna and Milwaukee is also true. As to the second factor, I think that also favors apportionment, Your Honor, because the vast majority of the damages here, the attorney's fees recoverable here, are attributable to the $200 million in punitive damages on real water. So there is no risk that if the compensatory damages or the attorney's fees arising from the compensatory damages are appropriated, that there is a risk to plaintiffs not recovering, a substantial portion of their damages. And then, Your Honor, obviously, without a full discussion of the pre-judgment interest calculations and the offset, we can't, have hard numbers today as to what a total attorney's fee amount should be. But in regards to the Beatty factors, Hanna does maintain that a decrease of the total attorney's fee sought is appropriate to comply with the reasonableness requirement. And specifically what we proposed, Your Honor, is after the attorney's fees are apportioned, the court should take into account when the offers of judgment were made. Here, they were made 75% into the life of the litigation. So the attorney's fees awarded should take that into consideration and limit it to 25% of the contingency fee amount apportionable to him. And unless there's anything further, that's it.
No further questions, sir.
Thank you.
Anyone else from your defense?
Your Honor, first of all, I think Mr. Odou and I are in agreement that the 40% is not applicable to Gallagher and Haley as to real water. I think that's pretty clear in the brief, but if it's not, I'll put that on the record now. So that solves that problem. His first argument is that they didn't have the ability, after accepting the Haley and Gallagher offers of judgment, to accept more offers of judgment because of what their insurance company did. Well, what their insurance company did is they went to the bankruptcy trustee, offered him $400,000, got him to sign a settlement agreement, repudiating his previous agreement with us. This is the conduct he says is reasonable that justifies him not paying. And that was an insurance company decision. An insurance company decision to be super cheap, or try to be super cheap rather than at least respond to the offers. So that's solely their decision. That has nothing to do with us, Your Honor. It's certainly not a reason that should be considered on the Beatty factors. Then on Belsky was a 2018 case. Okay, that didn't have a limited insurance situation. That had $7 million worth of insurance. So despite that, they didn't pay the Belsky offer of judgment. So insurance had nothing to, an insurance limit had nothing whatsoever to do with that. But even if it did, Your Honor, their fundamental position here is that they can reject offers of judgment and pay no one. It's not like they paid this insurance proceeds to someone else in some other settlement. They haven't paid anybody. Okay, Real Water paid Haley, and the Gallaghers. They have not paid anyone else. So they say they have limited number of insurance. I think it's 16 million over the time period in question, 2016 through 2021. But they're not paying anybody, so they can't not pay people and say that the reason we're not paying these offers of judgment is because we are paying people. They haven't paid anybody. The offset issue, we have to figure out what the amount due is, including the fees and interest, and then we calculate the offset. I think we went through that last time. I just mentioned that because make that clear. And then he says it's shocking the amount of the attorney's fees. Your Honor, this is a big case. Okay, jury came out with a big verdict. That's what the contingent fee is. If it had been a small verdict, it'd be 40% of the small verdict, moderate verdict, 40% small. But that was the actual verdict, and that's what the 40% contingency fee applies to. There's no rule that says we're not going to follow Rule 68 of Capriati if there's a big verdict. Then he says it violates the bankruptcy state potentially to seek punitive damages from real water. We filed a stipulation with the bankruptcy court, which we've also filed with this court, so it can see what it says, that we've agreed to collect only from the insurance policies. That's always been our agreement. That's still our agreement. So what's really happening here is the insurance company who has had demands within policy limits and now is liable for the whole thing in our view. They're arguing that, oh, well, you're really trying to get from real water. We're not. And then they say, oh, under Capriati, you should just give the plaintiff $500 an hour. That's not what that decision said. That's not what that decision did for Mr. Prince. What it said, and it went through it in a lot of detail, is that the attorney fee does not vest until after verdict. It's the time that the attorney's fees entitlement vests that's you should be focused on. Here, it clearly vests after the verdict, just like Capriati. And then Milwaukee comes in and says, we have a limited insurance policy. Again, they are forgetting the fact that they have 3 or 4 years worth of coverage. It's well under the amount that was made. So we demanded $3 million for 7 people over 3 different policy years. So it's well within that. So that wasn't the reason they didn't pay it. The reason they didn't pay it is because they're also insured by Liberty, and they went in and they canceled a mediation because they said this bankruptcy trick is going to work so well. Milwaukee actually had a mediation scheduled. So for them to come in and say that they didn't pay it because for any reason other than the truth, which is that Liberty was trying to get the bankruptcy trustee to suck us back into bankruptcy court. That's what really happened here, Your Honor. Then they say, oh, well, the medical expenses are so low and the verdicts are so high. Well, there's no treatment option for acute liver failure other than you get better or you have to liver transplant. So people that get better have limited, they can't do electroshock on the liver. They can't shoot drugs into the liver to make it work. There's no expensive medical treatment for acute liver failure case, except to get the liver transplant. So the medical expenses were in no way a proxy for the serious injury in this case. And I think it's been admitted by all the experts that acute liver failure is an extremely serious injury. So, I mean, if that's their claim that they knew that it was acute liver failure, they didn't take it seriously because they thought it wasn't a serious claim. Shame on them, Your Honor. Then they come in, they say, oh, well, we rejected the offer because hydrazine was a new theory. That wasn't new, Your Honor. The FDA testing was done in October 2021. October 2021. It was revealed to all the parties shortly thereafter. That's where they found the hydrazine. Some of the offers of judgment weren't made until March 2023, 17 months after the hydrazine. And they were made after Dr. Kosnet filed his report. He was our toxicologist, talked about hydrazine in detail. I don't think they've really challenged that 40% is reasonable for a complex product liability case, but it certainly is, Your Honor. We've talked about the Capriati vesting issue. Hanna says we had limited information. That's their argument. They refused the offer of judgment because we had limited information. Well, if they wanted more information, they should have asked for it. But here's the information they had. 1, they knew their product was being used. They had over 100 invoices to Real Water. 2, they knew about the rocket fuel because, as I've said already, it came about in October 2021. 3, they knew about they knew in detail about the meter problem, that the meter wasn't measuring right and that Aikens added more concentrate because we took Aikens' deposition right away in the litigation. That wasn't done late. We went to Judge Gonzalez and got an order to take that right away. That was done in the first couple months of the litigation. So that's the information they had, and given how low the offers were, they certainly should have been paid. With regards to this apportionment issue, I just don't understand this. They say they're different defendants, they're in different positions. Well, Hanna and Milwaukee were both distributors in this case. You know, Hanna Romania was the manufacturer, sent it over to Hanna US. And then from Hanna US to Milwaukee, they were both distributors. They have a common owner in this case. Mr. Savaggio, who I guess became a doctor suddenly, Mr. Savaggio is the vice president for one and the chief executive officer for the other. So there's really no separation in my mind between Hanna and Milwaukee. Certainly not a separation such that there should be some grandiose apportionment. You know, that they're not liable for 40% of the punitives because punitives weren't rendered against them. So the only amount that would be determined here would be, I can't remember the exact number, 30 something. But that's the only thing that they're 40% and that is a relatively small number. Finally, on the policy concerns, I haven't heard anyone say anything about the policy concern here, which is it's to promote settlement. These defendants, not only did they roll the dice, but the conduct of the insurance company in trying to undercut the plaintiffs through the bankruptcy court, that's the real reason these offers were rejected, Your Honor. And Mr. Odou pretty much admitted that because he specifically said they accepted the Haley and Gallagher offers of judgment. And then the insurance company had this great idea to run over the bankruptcy court. So we have a bad motivation for rejecting the offers, not in this case, not just stupidity or you know, failure to investigate adequately. You actually had a bad motive. So for these reasons, we think the 40% is appropriate. We think it should be awarded just like it was in Capriati. And again, I think all we're asking is the court enter an order that the 40% be awarded. We'll apply it to the total compensatory damages when the interest is figured and the costs are figured. Thank you, Your Honor.
Yeah, Mr. Polsenberg.
Just for my record, Milwaukee is not a distributor of real water.
I have one question, and I was listening to the insurance inadequacy of insurance defense. Is that the best way to categorize it?
Inadequacy of insurance, Your Honor.
Yes, and you know, as far as insurance is concerned.
Yeah, I Joel Odou for real water. Not coverage counsel. My opinion on coverage doesn't really matter.
I understand.
And you know,
I really respect that. I do.
it just doesn't matter. Yeah.
But I was looking at it as it relates to the office of judgment, and my thoughts were I was listening and said, well, you know, we just didn't have enough insurance. Why wouldn't all the insurance policies just file an interpleader and throw the insurance out there and say this is all we got?
Your Honor, I can say this.
Because I thought about that.
That
Happens,
is
right?
something that they argue exists in the bankruptcy court right now. The plaintiffs vehemently disagree, and I don't wish to get drawn into that because that's for other lawyers and other courts. But I think it's safe for me to say that we disagree on.
Anybody else want to comment on that? And then, of course, I'll give the plaintiffs an opportunity to do so. Ma'am.
I believe some policies, if you give the policy limits, then that would exhaust the policy and it would make it so there's no obligation to defend anymore, which could be construed as bad faith.
I understand. Okay. Anybody else want to comment on that? Anybody
Just point out that we made the offers of judgment serially. We made them 2 weeks, 2 weeks, 2 weeks, 2 weeks. And the reason we did that is to precisely avoid the argument that we were eliminating the duty to defend, and they still rejected the offers.
I understand.
I believe Milwaukee's offers all came together.
And ultimately, I don't mind saying this. I just had a question. That's all. That's not going to ultimately control my decision. And anything else on this topic?
Your Honor, I will make one more point, which is just that, you know, we've talked about the relationship between the disclosed medical damages and the offer of judgment amount. And Mr. Kemp said, well, but, you know, look at Mr. Hugh and the Ryerson estate, and that in fact those offers of judgment or less than the disclosed medical expenses. I'd say even if you're inclined to award attorney's fees as to some of the plaintiffs, I'd say at least for Belsky and Haley, because of the gross disparity between the disclosed damages and the offer of judgment, that at least attorney's fees be denied as to them.
Yeah. Any last response to that, Mr. Kemp, Mr.
No, Your
Parker?
Honor.
Is that a yes or no? I just
No,
want
Your Honor. No, no, Your Honor.
Okay, I,
I wanted to get up. If he, this.
do we have time for any others?
Your Honor, the problem is the other one involves the interest. Mr. Peppermint's not available for the interest.
That's okay.
So
We
we
have
have to pick another date for that.
Yes, because I have to go down and break these down individually as suggested, so.
Do you have Eric's calendar?
Only thing I can say is this, I am starting, I think on Monday, we start a 3-week jury trial, right?
Yes. We can do Thursday.
Thursday at 1:30.
No, he doesn't get back this week.
Oh.
Eric doesn't get back this week. He's on
No.
spring break.
But well, I think he can be on the phone. We can do it on the phone Thursday at 1:30.
Yeah,
Do that.
I'm thinking this is an hour.
You want to come back Thursday, 1:30?
I can't, but let me just clarify which one we're doing, because maybe I don't need to be here. I could send somebody.
We're doing the Milwaukee.
Doing interest and offset.
Hannah's motion on interest.
So I don't mind if you proceed without me. I can have somebody to monitor. If we join some arguments and I have to look to see exactly if we don't.
Your Honor, the alter amend judgment motion is meant to argue, and actually I cannot be available Thursday, unfortunately.
So is there anything else we can do Thursday?
Well, I think Dan's right, Your Honor. There's really not that much left.
Okay. It seems like to me, there's a lot left, but
Friday the 15th from 9 AM to 11:45 only.
okay, and I understand I have strict. They try to keep me under a rein because sometimes I get too optimistic as to when things can get done. And they tell me I have a really hectic calendar right now with trials and all those things. So for the record, once again, ma'am,
We can do Friday, 9 AM, the 15th, 9 AM to 11:45. We have to stop at 11:45. Otherwise, you'll have to reset them to April 9th at 2:30 PM. They won't be heard on that date, but we'll be able to determine when they can be heard after the pre-trial counsel call.
Yeah, Judge, why don't we try to do Friday so we can get them out of the way?
Friday works for me, Your Honor.
That's
Friday.
11:45 hard stop.
yeah, and the reason why, because in the afternoon, we're doing motions related for the trial, just so you understand
So
that.
what time start?
9 AM. And
Next docket's 1293 and 1298.
Everything that's on our calendar currently that is not heard is gonna be set then, but you guys determine what you wanna argue, and then anything else will be kicked on.
Yeah, we're submitting on the papers 1261, which is the motion to tax for retax.
Okay. All right.
Yeah, that'll work.
So that'll work on Friday?
Yes, Your Honor.
Friday the 15th, 9 AM.
Okay, here's my next question. We have a couple of, it appears to be unopposed motions. And I think they were motions to seal. That plaintiff's motion to seal addendum to plaintiff's opposition to Real Water's water defendant's motion for new trial. And there's another, and that's 1345. And we have 1350, which is plaintiff's motion to seal addendum A to plaintiff's opposition to Milwaukee Instruments motion to alter amend.
I'm fine with the addendum A. I thought that already was sealed, told the truth.
I thought we agreed last time to seal those.
Yeah.
Okay, if we didn't, we'll go ahead and grant them. Just to make sure, right, ma'am?
Yeah.
And so we need orders on this. Okay, with the appropriate findings, I have to do that under the rule.
I'll seal the order.
So for the record, Monday at 9 o'clock, Friday at 9 o'clock.
Friday at 9 o'clock.
Friday, and that will be March 15th at 9 o'clock AM.
Hoorah, thank you.
And we have to be done by when?
11:45.
We'll be done by then. Jeez. Even I'll be done by then.
Thank you, Your Honor. Joel Odou for Water Defense. I will not be here or be online, but I'll have somebody monitoring, but we have nothing to add.
In your honor, this is Joe Reynolds. I will not be here on Friday, but Mr. Galley will, and he'll be making the arguments.
That's,
Thank you.
you're welcome.
Thanks, Judge.
Oh, another day.